and my lord, the defendants were not before this honorable court as a result of the directive.
Can you speak up?
Okay. Milord, the defendants are not before this honorable court this morning. This is as a result of the directive I have just received this morning. That investigation has been escalated to an extent which need not to be disclosed, my lord. In the circumstances, may I be
last submission count.
Yes, my lord. Investigation has been escalated, my lord, for a reason which, my lord, I may not need to disclose, my lord, as a result of based on intelligence, my lord.
Yes.
So, my lord, in the circumstances, may I be asking for a very short adjournment? For a definite mention. Also, my lord, the first defendant, the third defendant, my lord, who is in Lagos, my lord, who is in Lagos, my lord, to be able to be brought down here to this state, my lord. Thank you.
You say the third defendant who is in Lagos?
The third defendant, my lord, who is in Lagos Command, Lagos State NJLA Command.
Yes.
My lord, and I will not have him been transported down here to your state, my lord. Thank you very much.
Okay, let me hear from the one of the defense counsel.
Yes, my lord. In view of the application made by the learned counsel for the prosecution, my lord, same having been the defendant are not before the court, and also the court cannot act on vacuum. So in view of that, my lord, we are urging the court to give a very short adjournment to enable the prosecution.
Prosecuting counsel suggested it.
May I be asking for
The sitting is distracted, my lord. The sitting is distracted.
My lord,
my lord, the proceeding.
The prosecuting counsel, I cannot hear you. And anybody who has joined this proceeding should please mute his device. Prosecuting counsel, I didn't hear the date you suggested.
Asking for the 13th day of October 2025, my lord, subject to my lord convenience.
Why not 14th? Just trying to print out the procedure. This matter is hereby adjourned to the 14th day of October 2025.
Thank you, my lord. We are very grateful.
You're most welcome. Call the next case, please.
That number FS is between period of Aminu.
Representation.
Respectfully, my lord, I am Usman Bamala. My humble appearance is for the complainant.
Excuse?
Yes, Mr. Smiley.
Yes.
Can you speak up?
Technical error, but we didn't hear that.
Mr. Smiley, so can you
Abdul Hamid Yahaya.
Yes, my lord. Yes. The defendant is present here to confirm. He's out, my lord.
What is his name?
His name is Abdulhamid Yahya, my lord.
Okay.
Yes, my lord.
Respectfully, my lord, may it please this honorable court, my lord,
Yes, go ahead.
MP Ngohi, humbly announcing my appearance for the defendant, my lord.
Yes.
Yes, my lord, the matter is fixed today or is coming up today for judgment, subject to my lord convenience. We are ready.
Abdulhamid Yahya, wannan lauya ne mai kare yake gabatar da cewa yau ita ce rana ta yanke hukunci kuma a shirye yake, wanda yanzu ya faɗa kenan.
The judgment of the court will be delivered shortly.
As court, please, my lord.
Judgment.
As court, please, my lord.
Before this honorable court, the charge filed by the National Drug Law Enforcement Agency, NDLEA, against one Abdul Hamid Yahya, dated the 12th day of May 2022. The defendant was arraigned on a 2-count charge for being in unlawful possession and dealing in 2.8 kilograms of cannabis sativa, a narcotic substance similar to cocaine, heroin, and LSD, contrary to and punishable under sections 19 and 11C. The National Drug Law Enforcement Agency Act, N30 Laws of the Federation of Nigeria, 2004. Upon arraignment, the defendant pleaded not guilty to both counts. The prosecution, in proof of its case against the defendant, called 3 witnesses and tendered several documentary exhibits, while the defendant testified as DW1 in his own defense. The case of the prosecution. The case of the prosecution was presented through PW1, PW2, and PW3 is that the defendant was arrested on the 28th day of January 2022 at the New Market, Damaturu, during a raid operation led by Chief Superintendent of Narcotics, Dalis Bambis. He was allegedly found in possession of 3¼ blocks of dried weed, later confirmed by preliminary and forensic testing to be cannabis sativa, weighing 2.8 kilograms. Can you hear me?
Yes, my lord, very well.
Okay, thank you.
Yes, my lord.
Yes, my lord, we can hear you.
Okay. PW1 testified that the defendant admitted ownership of the substance at the time of arrest and volunteered a statement which was recorded by PW2 Buhari Salisu in both Hausa and English versions. The statement was made after the defendant was duly cautioned and in the absence of any legal counsel or relative. He authorized PW2 to write the extrajudicial statement on his behalf. In the statement, the defendant confessed to ownership of the exhibit and further disclosed that he had been dealing in cannabis sativa supplied to him by one Ahmed Issa residing at Nainawa, Damaturu. PW3, Suleiman Mohammed Rabiu, an assistant superintendent of narcotics 2, and the exhibit officer testified that he received the exhibit from the arresting officers, carried out a preliminary test, which confirmed the substance as cannabis sativa, weighed the substance 2.8 kilograms and packaged it into 2 parts marked A1 and A3. He forwarded the sample marked A3 to the NDLEA Forensic Laboratory in Lagos, accompanied by the requisite request for scientific aid form, where the forensic report, exhibit NDLEA Abdul Hamid 3A, confirmed that the exhibit was positive for marijuana cannabis. The prosecution tendered several exhibits, including the defendant's extrajudicial statement, Exhibit NDLA Abdulhamid 1A and 1B, certificates of test analysis, packing of substance forms, request for scientific aid form, the drug analysis report, and the exhibits themselves, that's the bulk and remnants of the cannabis, all were admitted in evidence without objection. Case of the defense. The defendant, Abdulhamid Yahya, testified as DW1. He denied ownership of the cannabis sativa, claiming that it belonged to his late friend, Kaua, with whom he was arrested. He asserted that he was only at the location to meet a friend when NDLA officers raided the area and arrested everyone present. He claims that the weed was found in Kaua's possession and that he was unjustly implicated. However, under cross-examination, the defendant admitted that he had previously faced a drug-related charge before this same honorable court, and further conceded that the deceased co-accused Kaua was found with the weeds during the arrest. He nonetheless maintained that it did not belong to him. Issues for determination. The issues calling for determination in this case are: one, whether the prosecution has proved beyond reasonable doubt that the defendant was in possession of 2.8 kilograms of cannabis sativa, and two, whether the prosecution has proved beyond reasonable doubt that the defendant was dealing in the said narcotic substance without lawful authority. Evaluation of evidence. It is tried law that in criminal trials, the burden of proof rests on the prosecution to establish the guilt of the accused beyond reasonable doubt. See sections 135(1) of the Evidence Act and a plethora of cases. The offense of possession and dealing in cannabis sativa under sections 11C and 19 of the NDLEA Act requires the prosecution to prove that: one, the substance found is indeed cannabis sativa, an illicit drug; two, that the defendant was in possession of or dealing in the said substance; and three, that such possession or dealing without lawful authority. That's three. On the first element, the prosecution led credible evidence through PW1 and PW3, who conducted the preliminary test, and through Exhibit NDLEA Abdulhamid 3A, the drug analysis report issued by the NDLEA Forensic Laboratory in Lagos. The report conclusively confirmed that the substance to be cannabis sativa marijuana. This element is therefore proved. I so hold. On the second element, the prosecution's evidence that the defendant was found in physical possession of the substance at the point of arrest was consistent and unshaken. PW1, PW2, and PW3 all identified the defendant as the person arrested with the black polythene bag containing the cannabis sativa. The defendant's extrajudicial statement, Exhibit NDLEA Abdulhamid 1A and 1B, voluntarily made, clearly states, "I'm the owner of the 3.5 blocks of weed found with me during my arrest." This direct confession, made freely and voluntarily, remains the strongest evidence against him, as held in Ekimson versus State 1989 3 WNR and Nachuku versus State 2007 17 NWLR. The defendant's attempt during oral testimony to retract the confession carries little weight in the face of overwhelming corroborative evidence from the three witnesses and forensic exhibits duly linking him to the recovered exhibit. On the third element, there's no evidence that the defendant was authorized by law to possess or deal in cannabis sativa. The NDLEA Act criminalizes such possession or dealing unless authorized under a lawful license, which is not the case here. The defense offered no such lawful justification. The defendant's story that the drugs belong to the deceased Kaua is inconsistent with his own earlier confessional statement and is therefore an afterthought. The evidence of PW1 and PW3 that the defendant and the deceased were found jointly selling the drugs at the joint area, and that a pre-purchase operation had earlier been conducted, confirming his involvement stands uncontroverted. I find the testimony of the 3 prosecution witnesses credible, consistent, and reliable. Their evidence was not discredited under cross-examination and was fully supported by documentary and physical exhibits properly admitted in this trial findings. From the totality of the evidence, this court finds that 1, the prosecution has proved that the substance recovered was cannabis sativa. 2, the prosecution has proved that the defendant was in possession of and dealing in the said substance. And 3, the defendant did so without lawful authority. The elements of the offenses under sections 11C and 19 of the NDLEA Act have therefore been proved beyond reasonable doubt. Conviction. Consequent upon the findings above, the prosecution having succeeded in discharging the onus of proof placed on it beyond reasonable doubt, accordingly, the defendant Abdul Hamid Yahya is found guilty as charged on both counts of the offense of unlawful possession and dealing in cannabis sativa 2.8 kilograms, contrary to and punishable under sections 11C and 19 of the NDLEA Act, Cap N30 Laws of the Federation of Nigeria, 2004. The defendant Abdul Hamid Yahya is hereby convicted as charged on both counts. The sentencing hearing is to commence now. Can you interpret as much as you can, Mr. Salisu?
Yes, my lord. Abdulhamid Yahya, yau ita ce rana da kotu take tabbatar da za ta tabbatar da hukunci akan tuhuma da ake ma ko in ce shari'a da ake gabatarwa yanzu. Daga dai ranar da aka kawo ka gaban kotu zuwa yanzu da shaidu da aka gabatar da su masu kawo ka da irin shaidu da suka bayar duka, a nan kotu ta yi aikinta a kai ta tabbatar da shaidu sun bayar da shaida kamar da doka ta faɗa, kuma an samu kyakkyawan shaida a kan kaɗin. Kotu kuma ta aminta da cewa lalle kai mai laifi ne, wanda yanzu haka akan wannan tuhuma da ake ma na kilogiram 2.28 a kansa da a yi maka hukunci.
Any previous conviction?
Yanzu kamar yadda kotu take sanarwa.
The prosecuting counsel. Can you find out why the I can't see the prosecuting counsel? It seems as if the prosecuting counsel is no longer online. Mr. Salisu.
My lord.
The term is for early cases. Can you ask the defendant if he has anything to say to the court?
As God please, my lord. Abdulhamid Yahya, kotu ta ce a tambaye ka ko kana da wani abin da za ka iya gaya wa kotu? Ka ɗaga muryanka ka yi magana, ana rai. Ɗaga muryanka sosai.
Ina neman alfarma a wajen wannan kotu.
Ba a nan ba ne. Kana da wani abin da za ka iya gaya wa kotu?
No, let him go ahead. Allow him, let him go ahead.
To ka ci gaba da maganan ka. Ka ɗaga muryanka.
Ina neman alfarma a wajen wannan kotu da ta min alfarma a game da laifin da take tuhuma na da shi.
Can you interpret?
Yes, my lord. My lord. He played the court that he needs to temper justice, my lord, on his
Yes,
side, my lord.
yes, let him go ahead.
Ka ci gaba.
Mahaifiyata tsohuwa ce tana tare da marayu kuma ni ne mai kula da su a halin yanzu kuma ba su da wanda yake kula da su.
My lord, his mother is all age and he is the one that is take care of his family. There is no assistant, only that they assist him.
Yes,
Ina ne alfarma da kotu ta min alfarma na yi nadaman irin aikata wannan laifi kuma insha Allah ba ran sake aikata irin wannan laifi.
He said, we need to temper justice, my lord, with mercy, my lord.
that he's showing remorse that he will not repeat it. That was what he said. Any previous conviction? Ask him.
An taɓa hukunta ka ne makamancin wannan? Ka ɗaga muryanka.
Zuma haka,
An taɓa maka hukunci makamancin irin wannan shari'a? Yes, my lord, he has previous record of conviction, my lord.
Anything else?
Akwai kuma wani abu?
Ni ɗan makaranta ne, ina so kuma in ci gaba da makaranta na da abu.
My lord, he is a student and he need to continue his study in the school.
Yes. Is that it?
Yes, my lord.
Defense counsel?
Yes, my lord. The defendant standing trial before this honorable court, my lord. The convict, sorry, my lord, the convict standing before this honorable court, my lord, is the only child from his mother. And also a student.
Counsel, are you still there?
Yes, my lord, as a result of this business, even drop out of the school, my lord. Because he is under the custody of the correctional. And even presently, he is serving a punishment sentence under the first case, who is already a convict. My lord, he learned a lot of lessons being stayed in the correctional service, my lord. And now he's ready, my lord, to go back, continue with his service.
He's ready to go back and continue
with his study, continue his education.
Yes.
And in view of my lord, we humbly apply that to my Lord to temper justice with mercy. When sentencing the defendant, the convict, my Lord. Thank you, my Lord.
Abdulhamid lauya mai kare ka ya ce a kotu yana neman alfarma saboda kasancewar ka kai ɗalibi ne kuma kai ɗaya ne a wajen mahaifiya kuma kana tallafa mata sannan kuma gashi an kawo ka wannan gidan gyaran hali wanda yake tabbatar da kotu cewa ka ɗauki darussa da yawa a nan gidan gyaran halin kuma yana roƙon kotu da amma afuwa saboda kai ɗalibi ne kuma za ka koma za ka ci gaba da karatu a makaranta kamar yadda mutum ya tsaya to haka lauyan kai.
The prosecuting counsel.
Lord, the convict, my lord, has a previous record of conviction. Which is why in custody right. And the conviction, my lord, it is by this honorable court, and I believe the court has taken decision. So, my lord, the circumstances, my lord, I always defendant because
Your submission, counsel.
I urge this honorable court sentence the convict, my lord, to serve as a deputy, my lord. Thank you.
Sentence.
Escort police, my lord.
When I typed in the name of this case on my laptop, a similar name to the defendant came up, signifying that a standard trial on similar offense, similar narcotic drugs, and measurements. The information which was stored in the laptop memory, and now checked the file in the system bearing the name of one Abdulhamid Yahya, CR/15/2022, confirming that the defendant is indeed before this court facing similar charges and was granted bail. And while on bail, he is alleged to have committed a similar offense. What got me worried and kept agitating my mind is that the defendant is before this court so soon after being charged for a similar offense, meaning as he's undergoing trial, he's back to the same illicit trade. The fact that possessing and dealing in illicit drugs have been adjudged as an organized economic crime, it seems as if the defendant is an old hand who feels that whenever he's arrested, he will be arraigned, get a counsel and apply for bail, and then readily go back to the same illicit business in the hope that even if he's caught, it's a question of a few months incarceration and he will be released to return to the business and make good money in illicit dealing and trading in drugs. Mr. Ilyas, can you interpret to him?
Yes, my lord. Mr. Ilyas. Okay. That's Mr. Ilyas. Abdulhamid, kotu ta ce, lalle a lokacin da aka kawo ka, aka kama ka da wannan laifi, akwai wani shi ma laifin da ya zama suna kama a daidai lokaci ɗaya a waje ɗaya wanda har an samu beli naka kenan. Ka fita bayan belin kuma ka je ka ci gaba da yin harkokinka har ya zo ka ƙara tabbatuwa ka dawo gaban kotu kamar yanzu haka yadda take yin magana, ko ba ka ba? To,
okay. Wanted to.
Yes, my lord.
Okay, go ahead.
To, sai ka ƙara yanzu makamancin wannan laifin shine wanda yanzu haka ka tabbata ya dawo ake magana a kai a yanzu haka. Ka gane? Ko ba gane wannan ba?
This young adult is already a convict in a similar case where the court found that he introduced a much younger person to sell illicit substance on his behalf. That younger person, Kawua, eventually died in custody before the end of trial.
Shi kuma wannan shari'a da ake gudanarwa din, akwai wani wanda Allah masa rasuwa a nan a cikin prison mai suna Kawuwa, wani mai karancin shekaru shi ma, wanda tare ne tuhumar take kai da shi, wanda shi ma ya rasu a cikin wannan shari'a duka ake yin magana yanzu haka. Ka gane ba? Yes, ma'am.
While convicting him on the 12th March 2025, this court held that in relation to such defendants who procures others to sell on his behalf, will also be concerned with the kind of victims he introduces into this nefarious trade. This enables the court to assess the defendant as either an incorrigible dealer or trafficker or a novice who has only been introduced into this illicit business. The sales boy unfortunately died in custody. The factors which the court will consider are almost inexhaustive, all being in an effort to locate the station of life of the convict in order to impose such punishment as will meet the justice of his case.
Sannan kuma kotu ta ce, a wannan lokacin shi wannan ɗan uwan naka a wata rana an masa hukunci da kai kenan ko? An yi masa hukunci a ranar 12 ga watan 5 a shekara ta 2022. Sannan shi Allah ya ɗauki rayuwarsa a wannan gidan gyaran halin. Sannan kai kuma da kake waje sai ka je ka ƙara faɗaɗa harkokinka na wannan abu. Ba wai nadama kai ko kuma ka daina ba ne, ka ci gaba da har aka zo yanzu maganar da ake yi.
This is the reason why, in my view, judicial sentencing is perhaps the most important aspect of criminal justice and adjudication process, because it is in this regard that the law comes out real to the defendant convict and to the larger society. A casual attitude by the court to these issues will invariably lead the court to impose a sentence, punishment that may be too harsh as to defeat the attainment of the goal to seek the reform of the convict, and which may invariably impair the attainment of even the goal to seek for deterrence in both the convict and the larger society. In criminal jurisprudence, the two broad goals of judicial sentencing are first, to seek the reform of the convict as stated earlier, so that by the time he completes the penal custodial sentence which the court imposes, he will return to the society as a better and more responsible citizen who has respect for the laws of the land. The second goal is to impose such sentence as will serve as deterrence to both other persons who are yet to be caught by the proverbial long arm of the law, who are also involved in similar acts for which the convict is being punished. While the first goal focuses on the convict in the dock, the second goal, in my view, focuses on both the convict in the dock and the society at large, especially for persons who are or may be involved in similar criminal activity for which the convict is being sentenced.
That's good, please. Abdulhamid, kotu ta ce, ita dai a irin ƙididdiga da bincike da suka yi, dole dai ka kasance kai cikin masu harkar, kamar kai ɗin ka zamo kamar babba ne a harkar wajen bawa al'umma matsala, saboda a duk lokacin da hukunci aka hukunta mutum ya kamata a ce ya gyara, to daga koma ka ci gaban dole wasu da su ƙara kwaikwayon.
Sorry, my lord, I don't know if I can take over, my lord.
Kuma
Okay.
Let's
Let me take over the interpretation so that the defendant will understand you very well, my lord.
Okay,
go ahead.
thank
you. Special registrar.
Yes, kana ji na?
Kana ji?
Yawwa, kotu ta ce dangane da abubuwan da aka kama ka da shi, sannan kuma duba da halin da ake ciki, an kama ka aka baka beli ka sake dawowa, sannan kuma ga wani dan uwanka wanda aka kama shi mai suna kawo, aka kama ku tare kuka sake dawo, shi ya rasa ransa a wannan gidan gyaran hali. Kotu ta ce iya abin da za ta iya maka shine ta yanke maka hukunci wanda shi ne zai saka lallai a tabbatar da doka a kanka. Dalilin yin haka shine akwai dalilai guda biyu. Na farko, kotu ta ce domin kai karan kanka ne a baka abin da zai gyara maka halinka wanda za ka gyaru na dindindin, shine domin a gyara maka halinka sai sa za a yanke maka wannan hukuncin. Na biyu, kotu ta ce za ta yanke maka wannan hukuncin ne domin ya zama gargadi a gare ka da izina a sauran al'umma gaba ɗaya. Duk wanda yake da sha'awan yin irin wannan halin ma, in ya ga irin hukuncin da aka yanke maka ko kuma irin gyaran da aka maka, shi ma ba zai so ya aikata wannan laifin ba. So kaga gyaran yana a kanka kuma yana kan al'umma gaba ɗaya. Wannan kuma hakki ne wanda ya rataya a wuyan kotu domin ta tabbatar da cewa ta yanke maka hukunci domin a gyara halinka, sannan kuma a tsare waɗanda suke da za su yi sha'awan aikatawa a baya. Domin ita kotu tana hukunci ne a tabbatar da cewa an yi hukuncin, kuma jama'a su tabbatar da cewa sun gani an yi hukuncin. Ka fahimta?
Daga murya na fahimta. You understood?
Thank
you, my lord.
Having listened to the plea in mitigation made by the convicts as well as the defense counsel, my questions are: this young man, where are his parents or guardians? Why deviate at such a young age? He has taken the choice of destroying lives instead of contributing meaningfully to the society that nurtured him. He's destroying himself and co-opting other young persons into the same nefarious business and destroying the society by selling in the open such illicit substances. I've not seen any remorse when he was convicted earlier in the year, and I've not seen remorse today. This honorable court, having taken all that into account and having carefully considered the plain mitigation, the defendant is a young adult, but the menace of drug abuse and trafficking in Yobe State and across Nigeria continues to threaten our youth and national security.
Yes, Abdulhamid, wadda ta ce ta yi mamaki a yanda kake mai ƙaramin shekaru wanda ya zamana kana yin wannan harka don ce baka da wasu iyaye ne ko tsayayyu a kanka wanda za su iya maka faɗa a kai wanda za ka iya daina irin wannan harka mummuna. Sannan kuma bayan haka in ka bayan cutuwar kan naka da cutar da mutane na jihar taka har ƙasa baki ɗaya, saboda harkar taku tana cutarwa da al'umma sosai, tana ƙara ɓata al'umma. Shine gwamnati tana mamaki yadda baka da tsayayyu ne ko iyaye ko wasu tsayayyu a kanka wanda za su baka gudumawa ko su maka faɗa a yadda take ganin ka mai ƙaramin shekaru, bayan an hukunta kuma still ka ƙara yanzu ma kana ƙara neman fuskantar hukunci kamar yadda yanzu ake magana a kai.
Thank you. The NDLEA Act prescribes a minimum term of imprisonment for such offenses in line with Section 19 of the 19 and 11C of the NDLEA Act. The defendant is hereby sentenced as follows. 1, on count 1, for unlawful possession of cannabis sativa, the defendant is sentenced to 3 years imprisonment. On count 2, for unlawful dealing in cannabis sativa, the defendant is sentenced to another 3 years imprisonment. Both sentences shall run consecutively. The sentence shall be deemed to have commenced from today, the 8th day of October, 2025.
That's good, please, my lord. Abdulhamid Yahya, tuhuma guda biyu kamar yadda kotu tabbata a kansu ta yi hukunci, kuma ta yi hukunci daidai da laifinka. Tuhuma ta farko dai kotu ta ce za ka zanna a gidan gyaran hali na shekara 3. Tuhuma ta biyu ma kotu ta ce za ka zanna a gidan hali shekara 3. Kuma wannan shekara 3 din za su fara daga yau ne. Yau din nan lissafin su zai fara. Shine abin da kotu tabbatar da.
This shall be the court sentence of the convict in order to encourage the convict to quickly retrace his steps and return to the society as a changed person. The court hopes that this conviction will serve as both a correction and deterrence to the convict and others engaged in illicit drug trade. The fight against drug abuse and trafficking is fundamental to the moral and social stability of our society. In the final analysis, the exhibits tendered in this case, cannabis sativa and other related materials, shall be forfeited to the federal government of Nigeria and destroyed by the NDLEA in accordance with the law. The convicts have 90 days within which to appeal both the conviction and sentence if it's not satisfied the same.
That's good, please, my lord.
Salisu.
Yes, sir.
Kana ji na mai laifi? Yawwa, kotu ta ce ta yanke maka hukuncin shekara 3 na tuhumanka da ake na farko wanda an same ka da kayan laifi. Sannan ta sake yanke maka shekara 3 na safara da kake na kayan laifin da aka kama ka da shi. Wannan shekara 3 da su tafi ne a jere ba wai ɗaya yana shiga cikin ɗaya ba. Kaga shekara 6 kenan an haɗa duka biyu. Ka fahimta? Sannan kuma cewa an yanke maka wannan hukuncin ne domin ya zama izina a gare ka da kuma izina a wurin duk wanda zai aikata wannan laifin. Sannan kuma an yi haka ne domin ƙasanmu da jihanmu da kuma duka al'ummanmu su gyaru don a samu sauƙi a wannan annoba na miyagun ƙwayoyi da yake faruwa. Sannan kuma abin da aka kama ka da shi kotu ta ce a mayar hannun su NDLEA domin su lalata shi. Sannan kuma kana da dama na ɗaukaka ƙara daga yanzu har zuwa kwana 90. Kana da daman ɗaukaka ƙara idan kana so. Ka gane hukuncin ko? Dan yi magana da ƙarfi.
Na gane.
Madalla.
Copy next. Okay.
My Lord, with your kind permission, I humbly apply the case number 9 on the first list to be called out of turn because I have another matter in a different court, my Lord. Thank you.
Okay. Application granted.
Thank you, my Lord.
Yes.
Number FSC/DM/CR/3/2025 between the Federal Republic of Nigeria versus Musa Ibrahim and one other.
One other. Who's one other?
Let's see. Right. Ibrahim Abubakar Blakos. Musa Ibrahim Abubakar Blakos.
Musa Ibrahim, there's Abdul Qadir Abubakar Bulakos.
Yes, Musa Ibrahim is present here at the correction center, my Lord. Musa Ibrahim.
Wannan shi Musa Ibrahim na Abubakar Bulakos.
Yes, my lord. Yes, the problem is at the correctional center.
Just a minute.
Thank you, madam.
Abdul Qadir is right here with me, my lord. Abdul Qadir is here with me, my lord.
Counsel, all defendants are to be in court, not with counsel at their chambers.
Because I am not in chamber, my lord. I am inside the court premises.
Let the defendants to be in the dock.
He's coming.
My lord, the second defendant is in the dock, my lord.
Respectfully, my lord.
Then give me a counsel. Second defendant in the dock in court.
Yes, my lord.
Why the first defendant?
Correctional center, my lord.
Okay. Thank you. Yes, representation.
My name is Usman Bamala.
Respectfully, my lord, MB Ngoyi, humbly announcing my appearance for the first defenders.
With humility to my lord, my name is N.D. Umar. I appear for the second defendant. Thank you, my lord.
The matter is selected today for commencement of hearing and subject to my lord convenience. We are ready.
I'm equally ready, my lord.
I am also ready, my lord.
May I apply the exhibit officer to appear in the witness box, my lord?
Yes, the exhibit officer.
Yes, my lord. The PW1 is present here at the correction center, my lord. And he's ready to affirm himself, my lord. Let me affirm myself, yes. I, Salif Isa, do solemnly affirm to interpret court proceedings from English to Hausa language and vice versa to the best of my ability, so help me God.
I, Megari Hayat Abubakar, do solemnly tell this honorable court the truth, nothing but the truth, so help me.
Yes, my lord, the PW1 is duly affirmed is male adult and a Muslim, my lord.
Yana can a petition.
Once again, tell this honorable court your name.
I am Megari Hayat Abubakar, Assistant Superintendent of Narcotic 1.
What do you do for a living?
I am the SB officer, Niger State.
And where do you work?
I work at the SB officer, NDLA, Yobe State.
For how long have you been working?
For almost 2.
Haven't been working for all this time. I believe you are an experienced officer. Am I correct?
Yes, sir.
Yes, sir. Tell this honorable court for all this time, what are your schedule of duties?
Schedule of duty, receiving a suspect and SB to recover from them. Testing the SB and weighing the SB. Putting SB A1 into white transparency pouch and A3 into SB room. Testifying and giving evidence in court when the need arise. Taking SB to Lagos for forensic and any ad hoc duty that assigned to me by my commanding officer.
Thank you very much. Tell this honorable court on whether you know these persons.
Yes, I know the defendant.
I think the other defendant, I can't cite him.
Yes, sir.
Can you see the which one? The one at the Pochiscom Correctional Center or the one in the court?
Can you see this? Not the one beside you. Yes, the
Can
one
you ask him to hands up?
open court.
Yes, I know him, Musa Ibrahim, and one Abdul Qadir, but he is not here with us.
Okay,
can you look at your screen? Look at the screen and look at the person raising his hands up.
Yes, he's the one, Abdul Qadir. I know him.
Okay, let me put it on.
So you know the two defendants, am I correct?
Yes, I know them, my lord.
Good. Tell this honorable court what you know about the defendant in this matter. Bearing in mind, the court is recording whatever you are saying. Make sure you observe the demeanor of the court. Whatever you say, you allow the court to record it before you make additional sentence. Please, you may wish to start.
Mr. Exhibit Officer.
My lord.
Did you hear the submission of the prosecution counsel?
Yes, my lord.
Yes, then go ahead.
On Tuesday,
yes.
On Tuesday, 19. On Tuesday, 25 January 2025, at about 17:00 hours, the two defendants were brought to me by Bagudu David as FN and Hilary Uja as N2.
Okay, get him a chair. Just a minute. Let's just give us a minute to give the defendant a chair to sit on. Can you hear me, Mr.?
Yes, my lord, we are hearing you.
Yes, my lord.
Just let him have it. Let him sit. And if there's a seat, you at the correctional center can sit as well. If there's whether it's for you to sit, if you want. Mr. Megari, you can sit if you want, or you prefer to sit. Or we have only one chair. Yes. Yes, go ahead.
On Tuesday, 25th January 2025, at about 17:00 hours, the defendant was brought to me by Bagudu David SN and Hilary Uja SN1, together with one big sack When I opened it, I found 30 blocks of dried wood substance. Wrapped with white saltet. I field tested the S-bit and counted it. It proved positive for cannabis sativa and weighed 15 kg. In the presence of two suspects, arresting officer, witnessing officer, and other officers. I wrote the case file number and the name of the suspect and the date and substance name on white paper and punch it on the back. The date, which is on 25th of February 2025. Case file number NDLEA/YBAC/003/2025. The name of the suspect, which is Musa Ibrahim. and Abdul Qadir Bulokos. Abdul Qadir Abubakar Bulokos. And the weight of the S-bit is 15 kg.
Yes.
On 24th February 2025, I take the forensic to Lagos. And deliver it on the same date I received, which called my attention, Megari Hayatu Abubakar, S-bit officer, Yobe State Command. And this is the estimate of the test. This is it.
Sorry. Thank you, Megari. In the course of your testimony before this honorable court, can you hear me, please?
Yes, my lord.
You informed this honorable court that when the defendant was put before you, you issued some exhibit documents.
Yes, my lord.
Which include the certificate of assess analysis and packing of the substance form, where you fill the necessary columns.
Yes, my lord.
As well as the arresting and witnessing officer equally filled their respective columns and signed, whereas the defendants equally affixed their thumbprint on it. Am I correct?
Yes, my lord.
Good. You later informed this honorable court that you took a sample of the said exhibit for forensic analysis, where you received a response in a brown envelope. Am I correct? Calling the attention of this honorable court. Sorry, calling your attention as the OC exhibit. Am I correct?
Yes, my lord.
If you see the said documents, will you be able to identify it?
Yes, my lord.
How can you identify it?
With my name, my signature, the names of king and witnesses are there.
Now, where is the brown envelope as well as the analysis drop certificate you talk about? Is it with you?
Yes, my lord. Yes.
Can you show it to me? Thank you very much. With me here is a certificate of the test analysis as well as the packing of the substance form. Is it this one that you're talking about?
Yes, my lord. Is the one.
So, my lord, we apply for the witness to unfold the brown envelope to ascertain what it contains.
Yes, go ahead.
Oh, this is the experiment.
Thank you very much. My lord, in the circumstances we sought to tender the certificate of the test analysis, the packing of the substance form, together with the brown envelope, the drug analysis report, as well as the white exhibit forged ballot in evidence before this honorable court.
Your submission again, your application again, counsel.
My lord, we apply to tender the certificate of the test analysis, the packing of the substance form, the white exhibit pouch, the drug analysis report, the request for scientific aid form together with the brown envelope evidence before this honorable court.
Your application, please, please for you to lift it up for the court to see. I can see the exhibit officer with the brown envelope with the whatever. But I've only seen two exhibits in the exhibit officer.
Yes, my lord. The drug analysis report, the request for scientific aid form, the brown envelope, as well as the white exhibit pouch is with the exhibit officer operation center, whereas the certificate, so the certificate of test analysis as well as the packing of the substance form is here with me, my lord.
Are you sitting on it?
Haven't the exhibit officer identified the said documents, my lord, and in proof of evidence, my lord, we have served the defendants, my lord, with the copy of the exhibit documents, my lord. So that is the reason why we sought to tender same in evidence before this honorable court.
Yes. None of the defense counsel have any response?
Yes, my lords, we are not objecting the application of the Execution Council for tendering the said document, my lord.
My lord, I equally hold no objection.
The following exhibit forms are hereby admitted into evidence. The certificate of test analysis form, the packing of substance form, request for scientific aid form as marked as NDLEA Musa Ibrahim 1A, 1B, 1C. While the drug analysis report, the white transparent evidence pouch, and the analysis exhibit, the brown envelope as NDLEA Musa Ibrahim 1D, 1E, and 1F respectively.
That's good, please.
Let's go, please. Mr. Megari, you equally inform this honorable court that you kept the bulk of exhibits which the defendants were brought with. You kept it in your own custody for safekeeping. Am I correct, please?
Yes, my lord.
Where is the exhibit? Okay. Can you tell this honorable court what is the identification number there?
The test number NDLEA BNC 003/2025.
We applied through the witness, my lord, to open the said tobacco bag to ascertain what it contains, my lord.
Go ahead. Yes.
First bit.
I didn't hear you, exhibit officer.
This is the first bit. 30 blocks, which is 2 kg.
Okay. Kindly read the identification number attached to the
This is the identification.
Yes, read the hearing of the court. Read it to the hearing of the court. Let the court know the reference number.
India 1BSC 003 2025.
Thank you very much. Thank you very much. Lord, having identified the bulk of exhibit ballots and having ascertained same, we sought to tender the bulk of exhibit in evidence before the Honorable Court.
Counsel, must I come to you every time? You are just sitting there doing nothing?
My Lord, I make an application.
Yes, I've heard your application. I'm waiting for the response of counsel.
Of the defense counsel.
My Lord,
Sorry?
on the side of the second defendant, I have no objection.
Yes, my Lord, we have no objection of the
Can you lift up one of the exhibits? The witness is to lift up one of the exhibits to show the court. Can you lift up one of the exhibits? Mr. Salisu,
Yes, my
can
lord.
you confirm the number of exhibits?
Yes, my lord. There are some affected by the problem like this, my
Can
lord.
you count how many they are there?
1, 2, 3, 4, 5, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 20, 26, 27, 28, 29, 30, my lord. My lord.
Thank you.
Thank you, my lord.
The bulk of the exhibit has compressed 30 blocks concealed inside the white bag weighing 50 kilograms is hereby marked as MDLEM Mr. Ibrahim 2.
Stop, please. Stop, please. That's all for the examination chief of the PW1 in this matter.
Yes, my lord, we have a few questions for the witness.
Yes.
In respect of first defendant, my lord.
Yes, go ahead.
What's your name?
My name is Megari Hayatu Abubakar, Assistant Superintendent of Narcotic 1.
That's good. Megari Hayatu, your duty is to receive the exhibit and the content. Am I right?
Yes, my lord.
I'm also right to say that you are not the one who arrested the first defendant standing trial before this honorable court.
Yes, my lord. I'm not the one that arrested him.
Megari Hayatu Abubakar,
Lord?
being the exhibit officer, you are not the one who conducted forensic test of the exhibit analysis.
Pardon? I did not hear you.
I say, being an exhibit officer of the NDLEA Yobe State Command, You are not the one who conducted forensic analysis of the exhibit.
Yes, I'm not the one.
Megari Hayatu,
My lord?
you mentioned in your testimony that you took the exhibit to Lagos and received the response on that very day. Am I right?
Yes, my lord.
Megari Hayatu, you know that we don't have a functional airport in Damaturu here. Am I right?
Yes.
Then how possible is that you took the evidence to Lagos on that very day and received a response on that particular day?
I not mention that I deliver a message and received on that day. But I did not mention that I took it from Damaturu to Lagos on the same day.
Megari Hayatu.
Just a minute, Counsel. I'm trying to record your...
Thank you, my lord.
Yes.
Yes, thank you, my lord. Megari Hayatu, who recorded the first defendant's statement?
I don't know, because this is not my duty.
Are you right to say you are not there when his statement was taken?
I'm not there. I am not there.
Megari Hayatu, when was the first defendant arrested? When?
They were brought to me on the same date. I don't know actually. On 25th, they were me on the same date.
Thank you, my lord. That is all for the witness.
Yes, my lord, I have a few questions, my lord.
Yes, go ahead.
Thank you, my lord. Master Witness, you said the defendants were brought to you with attached with the substance. Is that what you said in your statement?
My lord, my name is Megari Hayatu Abubakar, not Mr. Witness, sir.
Okay, sorry. Magari Hayatu, you said the defendants were brought to you together with the substance. Is that what you said?
Yes, my lord.
That means you don't know the owner of the substance.
Before field testing,
they were brought to you together with the substance. That means you don't know who owned the substance.
It is under their possession.
You say?
It was arrested under their possession.
You said they were brought to you. Were you the one that arrested them?
No, I'm not the one.
Thank you. Since you are not the one, that means you don't know who owned the substance.
The substance was arrested under the...
Sir?
The substance was arrested under their possession.
I said you don't know who owned the substance.
Yes.
You are all here. If you know the owner, then you know them. You know the owner. If you don't know who owns the substance, please tell this one that yes, I don't know who owns the substance. Those that arrested them will come and testify.
Your response?
They assumed the ownership. They were arrested under the possession.
Mr. Happy, you answer my question. I don't know why. I just said you are not the one.
He has answered the question. He said yes.
Sorry?
He has answered the question. He said yes since ago.
Okay, I didn't hear him. His answer was yes.
Second defendant counsel, can you repeat your question? Can you repeat the question?
If his answer was yes, the end of my question. Thank you.
Okay.
My lord, I have no examination. And we apply for the witness to be discharged from the witness box.
Application granted. Thank you, officer.
Thank you, my lord.
My lord, in the circumstances, my lord, as I have said, we have a sole witness today. May we be asking for a date, my lord, which we shall bring the rest of the witnesses and close it on that very day. Inshallah.
Give us a date. Council, 12 November. November, Council.
It's convenient, my lord.
I didn't hear
12 November.
November.
It's convenient to me, my lord.
one poker.
the first defendant, who is Musa Ibrahim?
My Lord?
The one, the person candidate is Musa Ibrahim? Okay.
Okay.
Matters called prosecuting counsel application is granted. Matter adjourned to the 12th day of November 2025. First defendant is to be remanded in Bethlehem Correctional Center to the next adjourned date, while the second defendant is to continue to enjoy the bail granted him to the next adjourned date.
As court, please manage. An ɗaga shari'an nan. Yes, my lord.
I want to confirm from counsel, Mr. Baba Umar Nuhu, were you having challenges listening to the proceedings?
As court, please manage.
Yes,
Yes, my lord.
my lord. Even though I am in the court premises, but sometimes I have a challenge, my lord.
Okay, what do you think the problem lies? Where do you think the problem lies? Is it from your
I can hear
from the network?
Sometimes the sound is too loud, my lord.
Okay.
It's too crowded. It's like there's interruption somewhere.
I see.
Yes,
is
my
it
lord.
the same with you, MB Ngohi?
Yes, my lord, I have no problem. I'm still within the court premises.
And you're not having any challenges with the audio or with the video?
Yes, my lord, sincerely speaking, yes. Unless if there is network problem in general.
No, I just wanted to confirm so that we know the next step to take.
Yes, my lord.
Okay, thank you, Mr.
I think it is only from this room where I stay. Maybe it is sound of something like that. I don't know.
Okay, if for next time, if you're having challenges, since you're within the premises, you can just enter the court hall and still use your gadgets while inside the court hall. Because for me here, I'm not having any challenge. Although the challenge I have today is I couldn't connect to Zoom through my laptop. I'm presently using my phone, so I could not connect through my laptop. But if you have any challenge, any counsel having challenge, if you're within the premises of the court, you can move inside into the court hall and we continue proceedings so that we don't have any challenges. Okay, thank you,
Thank you.
Council. Please
Thank you,
call the
ma'am.
next case.
Card number FSC/DM/CR/22/2025 between Pierre and Ismail Shatima Ismail.
Shatima Ismail.
Shatima Ismail.
Yes, my lord, the defendant and he speaks Hausa, my lord.
Mr. Salisu, are you having any challenges at your own end at 42?
Yes, my lord.
You are having challenges?
Yes, we are having a pressing challenge for the sound, my lord. Time when you speak, you hear what he said.
Okay. Sometimes the audio is very low. You can't hear me.
We are hear you now very well. Now cleared, my lord.
Okay.
Sometimes when a technical error there, we hear some error. When you speak, so he return to you speak for here, my lord.
Okay, like an echo.
Yes, it's echo, my lord.
Okay, thank you. We'll see what can be done. Technical team to take notes, please.
No problem. Thank you very much, my lord.
Yes.
God is present and he speaks Hausa, my lord. Shatima Ismail.
Okay, thank you. Representation.
Respectfully, my lord, my name is Usman Bamala. My humble appearance is for the complainant. My lord, the matter is fixed today for review of facts and subject to my lord convenience and that of the defendant. We are ready to proceed.
Yau ci gaba da shari'a. Wannan shi ne lauya ya gabatar da kansa yanzu. Kuma yau ita ce rana kotu abin da ya kada zuwa shi ne za mu ci gaba da shari'a.
Milord, the complainant intends to review the fact of this case through the exhibit officer in person of Mr. Maigari Hayatu Abubakar, an assistant superintendent of narcotics 1. Milord, I apply, he should be called to the witness box.
Yes, my lord. This matter is my lord already.
Once again, before we proceed further, my lord, I apply with the witness to be affirmed.
Yeah, go ahead.
I agree, do solemnly tell this court nothing but truth or heard nothing.
My lord, the PW farm, he is both adult and infant.
Once again, tell this honorable court your names and what do you do for a living.
I am Hayatu as attendant as bid officer for best command.
Wannan mai gaba akan da yake saboda sunansa bayan sunansa ya ce me ya aikinsa da matsayinsa na
Tell this honorable court what are your schedules of duties?
My schedule of duties: receiving a suspect of them, requesting the SBIT, weighing the SBIT,
aikin kawo masa lemu da za a zo da kayan laifin gwaje-gwaje zai ci gaba.
the SBIT is requiring scientific effort, analysis form, substance form, one into fancy push, putting the vote which SBIT members of
kawo da kayan laifin sannan da gudanar da kwarekwaren bincike sannan kuma shi ne hurumin ɗaukan ajiye wannan kayan har zuwa lokacin da ci gaba da yin shari'a.
Giving witness in the court when the need arises,
ana ba da shaida a kotu a wani
SBIT to Lagos for collaboration.
Tell this you know about this matter.
aikinsa shi ne yana ɗaukar samfuri shi wani zuwa ga ƙwararru a can Lagos don a gudanar da bincike a kan shi sakamako kuma an kawo sakamakon kamar yadda yanzu yake.
Tell this court what do you know about the defendant in this matter?
The defendant was brought to me on Friday, 9 May 2025 at about 00:05.
Ya ce ya gaya wa kotu me ya sani game da kai. Ya ce wata ranar Juma'a ranar 9 ga watan aka kawo ka gaban shi shine yanzu da ci gaba da yin magana.
He was brought to me by Abubakar Yashi and Sangir Hussein ASL2. Together, 1.5 block of dry weed substance and some loose quantities inside black leather.
Ya ce akwai wasu ofisoshinsu guda biyu suka taho da wata leda baka cikinta akwai wani gari na ciyawa a kulle kamar yadda yake faɗa. Wasu ofisoshinsu guda biyu sai suka kawo ka ana gane ba.
I field test the SBIT. It proved positive for cannabis sativa and weighed 1.3 kg.
Sannan wannan busasshen ganyen da ya gwada binciken su shi da binciken sai tabbatar wannan busasshen ganyen ta bar wiwi ne wanda nauyinsa kilogram ɗaya ne da nauyin wannan ganyen da aka samu a wajen nan.
I filled the SBIT forms and signed it and gave the suspect some printed on it. The arresting officer and witnessing officer signed their portion, and I write the case file number on it.
Sannan akwai wasu takardu da ya bayar. Takardar take ba da dama da shi wanda ya kamo ka da shi wanda ya kawo ka gaban nasa da shi kana kansa duka da su suka sa sunansu a ciki, kai ma kuma aka baka ka dangwala hannu ya rada duka ya bude maka takarda file kenan mai zaman kansa akan wannan tudun kamar da yake faɗi.
The case file number NDLEA/YBSC/019 2025.
Shi ne suka ba da lamba a wannan kesin na kamar yadda ya faɗa.
The name of the defendant on it, Shetima Ismail, and the date, that is 9 May 2025.
Sunanka da akwai ranar kuma ita ce ranar kuma ranar wata na wannan.
Thank you very much. Mr. Maigari, you informed this honorable court that when the defendant was brought before you, you issued some exhibit documents which you filled the necessary columns and defendant equally assisted to print on it. Am I correct?
Yes, my lord.
You equally informed this honorable court that you kept the bulk of exhibit in your custody for safekeeping. Am I correct?
Yes, my lord.
Can you tell this honorable court how you can identify the documents you issue as well as the bulk of exhibit?
I will identify it by my handwriting, my name, and my signature, and the date.
Yau, mutum ma ya tambaya akwai takardun shaida sannan kuma da shi ainihin kayan aka samu a ƙasar naka. Sai ta yaya za a yi shi ya bambanta wani da zai iya bambancewa saboda akwai sa hannu da ranar duka da ya rubuta
I apply to show the witness the said documents for identification.
Let's go ahead.
Is this the certificate of test analysis you talk about?
Yes, my lord. Yes. This is the one.
This is the packing of the substance form.
Yes, my lord.
Yes, scientific form.
Yes, my lord. It's the one.
Apply through the witness matter to bring forward the said bulk of exhibit for identification too.
Yes, go ahead. Education, go ahead.
My lord, this is the bulk of exhibit 1 and 2.
Thank you very much.
The lost quantity.
And these are?
This is the case file number.
Okay.
MDLES/YBSC/019/2025. And the name of the defendant, Shetima Ismail, and the date, 9 May 2025. And the weight of the exhibit, 1.3 kg.
Thank you very much. Melod, having identified the scientific documents together with bulk of exhibit, we sought to tender the certificate of the test analysis, the packing of the substance form, the request for scientific aid form, and the bulk of exhibit in evidence before this honorable court.
The exhibit officer,
My lord,
how many writings are there? The package.
pardon?
The exhibit, how many packets?
The exhibit is one block.
Okay.
1.5 block.
Okay.
And some,
Thank you.
some loose quantity.
Okay. Mm. The following exhibitions are hereby admitted into evidence: certificate of test analysis form, typing of substance form, request for scientific aid form are hereby marked as ND/NDA Shetima Ismail 1A, 1B, and 1C respectively. The bulk of the exhibit of compressed dry wrap with white sellotape concealed inside black polythene with some loose quantity is hereby marked as ND/NDA Shetima Ismail 2.
No, please. My lord, that's all for the examination in chief, my lord.
Can you ask the defendant if he has any questions for the witness based on what has just been, based on the procedure?
Ascot, please, my lord. Kamar yadda dai na gaya maka, wannan abin da aka zo aka nuna a kotu shine wanda aka samu wajen ka. Sannan kuma yanzu kotu ta ce a tambaye ka ko kana da wata tambaya da za ka yi wa shi saidan nan. Shi wannan saida kana da tambaya da za ka yi mishi. Wannan mai bada saida akan naka. Kana da wani tambaya ne da za ka mar ko kuma baka da tambaya, ka yi magana a kotu ta ji. Ka ɗaga murya sosai. My lord, he has a question.
Yes, you can go ahead.
Kai ku tambaya.
Kayan da aka kama ni da shi a rarrafe a leda ne. A rarrafe a leda ne. Kuma wannan kuma na ga gari ne. Da
Yes, my lord, as he said that the my lord, that he said the exhibit that they arrested with him is rough, but he seen this one that the one that we show that lost quantity that affected by the rodent.
He did not say affected by rodents. We are just to interpret what he said, nothing more, nothing less.
As God please, my lord.
We interpret exactly what he said. You are not to add or to subtract.
As God please, my lord, sorry. As he said, the one that is arrested is rough before. The only thing that is.
Okay. Let the witness answer the question.
My lord, the loose quantity, this loose quantity, it is inside one black leather, and the black leather, it was rotten. That's why we just leave it like this. And this is the SB that was brought to me. We have the witnesses, that's the arresting officer and the witness officer.
Can you interpret to the defendant?
Yes, my lord. Kamar yadda wannan yanzu yake faɗa. Ya ce wanda kake faɗa ɗin shi ɗin ne, ledan ne ya samu matsala sai aka juya shi haka kamar yadda ka gani. Ba wai wani daban ɗin ba ne, abin da yake faɗa kenan. Ya daga muryanka. Ka fahimta?
Na fahimta.
The defendant, apart from the loose quantity, the other wrapped one, the dried meat in wrapped one, was that what was he was arrested with?
My lord, the problem that I said before, we are not hearing. We are hearing. I'm not clear, my lord. Now.
Okay, the question is, I want you to ask the defendant that he has had the explanation about the loose quantity. But how about the ones that are wrapped? Those ones, were they the ones he was arrested with? Yes, the one the exhibit officer is holding. Can you show it to him?
Kotu ta ce, kamar yadda kai bayani, ka ce wanda aka samu a wajen kayan yi rafi, kai na wajen kayan yi rafi ne haka kamar yadda wannan yake. So shi kuma wannan saida da yanzu yake bayarwa, shi mai bada saida, ya ce, shi ɗin da na wajen naka, ga shi na
want this explanation. Just ask him the one you are holding. Is it part of the exhibit in his possession when he was arrested? That is all.
Ta ce, mai shari'a ta ce, wai wannan watan na cikin shi ɗin ne, kamar wannan ɗin, shi ɗin ne wanda aka samu wajen ka? Shi ne? Yes, my lord, you understand.
Thank you. Now, please ask him again.
Yes, my lord.
When the recovered exhibit and what the witness says reflect the true position of the case.
My lord.
You did not hear him? Please ask him what the witness quoted. Does it reflect the true position of what happened? Okay, you still cannot hear me? Ask the defendant.
Yes, madam.
Whether the witness, Mr. Maigari, stated whether it is true that it reflects what happened.
Yes, madam. Shatima. Me shari'a ta ce a tambaye ka sai da wannan mai gari a kan naka. Shin haka ne? Sai da kai magana. Yes, madam. He said.
Asking whether, based on his what has just transpired, why does he have a reason why he should not be convicted? Is there any reason why he should not be convicted? Prosecutor Counsel, can you mute your device?
My lord.
Can you mute your device?
Mute your
Can you hear me, Correctional Center?
Yes, my lord.
Please ask him if there's any cause why he should not be convicted on his as charged. Is there any reason why the defendant should not be convicted on the charge? Ask the defendant.
As court, please, my lord. Court zai a tambaye ka ko kana da wani dalilin da zai sa ba za a hukunta ka ba? Wani dalilin da kake da shi wanda aka tabbatar da kotu wanda zai sa ba za a hukunta ka ba? Ka daga muryanka sosai.
Babu.
No.
The defendant, who is not literate in English language, indicated that he wanted the charge filed to be read to him in Hausa language. He pleaded guilty to the 2 counts when arraigned. The learned prosecutor consequently indicated his intention to conduct a review of the facts of the charge, to which the court granted the application for review of charge, and it has just been done now. This is an exercise which is peculiar to drugs and related offenses and was not meant to require the prosecution to prove an allegation in a criminal charge which the accused person had voluntarily pleaded guilty to. By the provision of the law, except in capital offenses, once an accused person has pleaded guilty to an indictable felony, punishable with a term of imprisonment, the court is empowered, especially in relation to the Federal High Court, who by Section 33(2) of its Enabling Act, Cap F12, Laws of the Federation of Nigeria, 2004, empowered to try criminal cases and matters summarily, to proceed to convict the defendant. The exercise to do a review of the facts was consequently done. Now, I've listened to the learned prosecuting counsel, Usman Bamala Esquire, who has produced certain documentary and real exhibits which have been admitted in evidence. It is one of the narcotic drugs, one of the substances which the extant legislation, that is the National Drug Law Enforcement Agency, Act Cap N30, Laws of the Federation of Nigeria, 2004, has outrightly, except where lawful authority is shown, prohibited its sale, possession, and consumption. The defendant, who on arraignment pleaded guilty, has not produced any evidence of lawful possession of the exhibits, and I am satisfied against his plea of guilty and the proof of exhibits that the case against the defendant has been proved beyond reasonable doubt as is required by sections 137 and 138 of the Evidence Act. In view of the plea of guilty entered by the defendant and in line with the provisions of sections 274(1) and 2 and 3561 and 2 of the Administration of Criminal Justice Act 2015, this court hereby finds the defendant, Shetima Ismail, guilty of knowingly without lawful authority, found and arrested in possession of 1.3 kilograms of suspected cannabis sativa, a psychotropic substance similar to cocaine, heroin, and LSD, and thereby committed an offense punishable under Section 19 of the NDLEA Act, Cap N30, Laws of the Federation. The defendant, Shetima Ismail, is hereby found guilty and convicted at charge.
As court, please, my lord.
I shall listen to the allegations of the convict before I pronounce on his sentence. Any records of previous conviction?
My lord, the convict has no previous record of conviction.
Shetima, ta gama kammala akan wannan shari'a. Da farko dai ka ansa laifi haka maka. Na mai tuhuma lauya ya ba ta wannan rana tabbatar da gaskiyar a fili kotu da gani da kuma shaida kamar yadda aka tabbata kuma an tabbata sai da abin da ya faɗa haka ne ka ansa haka ne abin da aka samu a wajenka kamar yadda sai da ya kawo kotu an nuna ma shine ka ce shine to kotu ta tabbatar ta ce to wannan kotun tana da fawar da ƙasar nan ta bata na gudanar da hukunci akan duk wanda ya kasance mai wanda ya aikata irin wannan laifin to yanzu ka aikata kuma kotu lallai ta yarda cewa ka aikata kuma za ta maka hukunci akan shi wannan laifin da ka yi ne za ta hukunta kamar haka sannan kuma kotu yanzu ta tambayi lauya mai gabatar da ƙara akan cewa an taɓa kawo ka an taɓa samun ka da makamancin laifi wannan ya ce a'a ba taɓa ba wannan shine na farko to yanzu dai kotu ta ce kana da in kana da wani abu da za ka iya gaya wa kotu sai ka yi bayani kamar yadda kotu ta umarta.
Ina roƙon kotun da daraja, ina roƙon kotun da daraja ta mun sassauci daidai da laifina.
Yes, my lord, you need a temper justice, my lord.
Yes.
Say me more.
Da ba zan kara aikata laifi irin wannan ba.
He is not defeated again, my lord.
Shine abin da zan roƙa wa kotu.
That is the end.
What do you do for a living?
Me sana'arka a gidanka, mazauninka?
Leburanci.
He is laborer, my lord.
What are you doing with this illicit substances? Are you taking it or selling it or both?
Aka samu a wajen naka, kotu ta ce a tambaye ka, me kake yi da shi? Kana sayarwa ne ko kana menene da shi? Tambaya ta ma. Me kake yi da shi?
Sayarwa ne na fara sayarwa.
Yes, he sell it, my lord.
Sentence.
As God please, my lord.
The convict, Shetima Ismail, was arraigned before this court. In passing sentence on the convict, the fact that the convict pleaded guilty to the charge on first arraignment and of the fact that he appears remorseful are factors which ought to inform the sentence which this court will pass. I take into consideration the mitigation made by the convict for himself, for the court to temper justice with mercy. It did not say, he just said he is a laborer without stating if he's a family man, but that he sells the illicit substances. This court has taken into consideration that the convict is a first-time offender before this court, but the court is also required, especially in cases involving illicit dealing in narcotics and controlled psychotropic substances, to take into consideration the nature of the drugs or psychotropic substance involved. In this case, I have to consider the amount of dried weed substance found with the convicts and the adverse effect and colossal damage it causes in society. Imagine how many people's lives will be jeopardized if it was not intercepted by NDLEA enforcement agents. Therefore, there's the need to give a deterrent sentence to send the message that such acts are not acceptable. The quantity of the dried weed recovered from his possession is about 1.3 kilograms, and it's a considerable amount, which betrays him as a commercial dealer, endangering the society in general by such nefarious business or activities. I'm left with the impression that in this illicit trade, judging by the quantity of the dried weed recovered from the convict, certainly betrayed him as an old hand. I have also taken considerations and analysis which I've done. I've also taken judicial notice of the fact that the convict had showed remorse by willingly or voluntarily assuming responsibility for his conduct by pleading guilty on arraignment, and also the fact that he's a first-time offender before the court. He's a young man with a bright future. It is to be noted that the offense for which the convict was arrested relates to possessing cannabis sativa, and such offenses relating to drugs are very serious offenses, particularly in this era of insecurity in this country. If the convict is one of the dubious businessmen, he should be seized forthwith. As a young man with a promising future, he should engage himself in legal business that will contribute to the development of the society, not to engage in such disgraceful activities that will destroy the lives of others. This honorable court encourages the convict to turn over to a new leaf and be informed Consequently, having regard to the considerations which are analyzed are factors which ought to inform the sentence which this court will pass in the final analysis, I hereby sentence you, Shetima Ismail, to 8 months imprisonment for the offenses you have been convicted of.
Court, please, madam.
To commence from today. The sentence is to serve as punishment to you and a deterrent to others. This honorable court admonishes you to stay away from crime or any of its appearances. Essentially, the essence of punishment is to obtain a reformation on the subject. You are enjoined to stay true to your words and lead an exemplary life after serving your sentence. The exhibit found in the possession of the convict without lawful authority shall be returned to the office of NDLEA and shall, as condemned substances, be confiscated and reputed to the federal government of Nigeria, and shall, pursuant to the extant laws of Nigeria, be destroyed by NDLEA by burning. At a public function, it will organize for the destruction of all judicially condemned narcotics and psychotropic substances. The event shall, on NDLEA's invitation, be witnessed by representatives of the Nigerian Police Force, the DSS, the Nigerian Civil Defense Corps, NAFDAC, National Environmental Standard and Regulations Enforcement Agency, as well as the press, both the print and electronic media. The convict has 90 days within which to appeal both the conviction and sentence if it's not satisfied with same.
Ask court, please, madam. Shetima, court ta yi jawabai kamar haka. Ta ce, ta yi la'akari da shekarunka. Na biyu kuma, ta yi dubi da irin ayyukan da kuke yi, kamar kuna ƙara bawa al'umma gudunmawa na lalacewa ne. Kuma dubi da halin da muke ciki a ƙasar nan na rashin tsaro. Duk wannan al'amarin yana ƙara ba da gudunmawa akan irin ƙara samun matsaloli kamar haka. Sannan ta ce kuma za ka zanna a nan gidan gyaran hali na wata 8. Wata 8, amma lissafin zai fara daga yau. Kuma tana gargaɗinka da ce ka fita ka ci gaba da irin wannan. In ka zanna wannan zama gyara hali, zama halinka ya gyaru da kuma ka zama mutum na gari, ba wai ka ci gaba da irin wannan ba. To shi ne abin da ta
Sentence to run consecutively.
Thank you very much. Zai fara yau yau. Yes, sir.
Cat number FSC/DM/CI/55/2 between Federal Front Nigeria and Damaturu.
The defendant is not here at the correction center.
Yes, representation, please. Fortiskum Correctional Center, can you mute your device?
Yes, my lord.
Representation. Prosecuting counsel. You're muted. I can't hear you. I think there's a problem maybe with the device because you're unmuted, but I can't hear you. Your audio is still very low. Can you try, because I do not know if I'm the only one having challenges hearing the prosecuting counsel.
We can't hear him, my lord.
So maybe can you increase the volume of your device? Maybe it's from the, because I can see that you are not muted, but we can't hear you. Instead of, why don't he should move here? Or yes, because we are just
Let me take him. Let me take my device to him, my lord.
Okay, thank you. We can move inside.
Let's take it.
Yes.
Respectfully, my lord, I am Usman Bamala. My humble appearance is for the complainant.
Yes.
Yes, my lord. With the greatest respect and humility to this honorable head, my name. My defendant, my lord.
My lord, the matter is selected today for continuation of hearings. And subject to my lord convenience, we are ready for continuation of for cross-examination.
Yes.
Yes, my lord, we are equally ready.
Let's go ahead.
My lord, the witness is with us, Mr. Abubakar Kumakasanda, who is the PW2 in this matter. Mr. Abubakar Kumakasanda, can you hear me?
Yes, sir. I can hear you.
If I can remind you, if I may remind you, the last time you were here, you testify as the prosecution witness number 2, where we sought to tender a document which is the confession statement of the defendant, which you recorded, in which we underwent a trial within trial where witnesses are called, and you were paused. The trial was paused for a mini trial, and now we are back. So we would like to continue from where we stopped. With this, my lord, I would like to submit that this is all we have, my lord, for the examination in chief. Let me give a space for the defense counsel to cross-examine the witness.
Okay. Sure. Counsel, you can go ahead.
Yes, my lord, we have a few questions.
Defense counsel, are you still there? I can see defense counsel. Mr. A. Baba is clear. Is he within the court premises as well? Mr. Abubakar Umar Sanda?
Yes, my lord.
Can you just mute your device for a few minutes before? Let's find
Yes, my
out
lord.
what the problem is. Okay.
Yes, my lord.
Thank you. Is the defense counsel back online? If the defense counsel, you're muted, station registrar.
Yes, my lord.
Madam is coming to use my device.
Can I go? Okay.
The defense counsel, are you ready?
Yes, my lord.
Okay, Mr. Umar Abubakar Umar Sanda, can you unmute your device?
Mr. Abubakar Umar Sanda, am I right to say that you are the one that recorded the statement of the defendant?
Yes, sir.
Mr. Abubakar Umar Sanda,
Yes, sir.
am I right also to say that neither the defendant lawyer nor any relatives were there when you recorded his statement?
Pardon?
Neither the defendant lawyer or any of his relatives were there when you recorded his statement. Am I right to say that?
Yes, the lawyer was not around, but one of his relatives was there.
Am I also
Let's go ahead.
Mr. Abubakar, am I also right to say that you were not there when the accused, when the defendant was arrested?
I was there.
When he was arrested, when?
Pardon?
When you said you were there when he was arrested.
Yes.
When was he arrested?
You mean the date?
Yes.
It was 17th August 2022.
When were you recorded his statement?
On the 18th.
Mr. Abubakar, how many NDLA officers were there when you recorded the statement?
So I cannot tell, I cannot say specifics, but there were many officers. When we went for the operation, we were a team of about 15 officers. So when we came back, some dispersed to go and look for breakfast, while some entered their various rooms, and then others were still within the command premises. That was when the statement was taken.
That means you don't know how many they are.
Yes, I cannot specifically call a number.
That is all my note for you.
Yes.
That is all my lot.
Thank you. Yes.
We have no examination, and that's all for the PW2 in this matter. I will apply PW2 to be discharged from the witness box.
Application granted. Thank you, Mr. Witness.
Thank you, my lord.
My lord, that's all we have for this case. We apply to close our case, my lord, having discharged our evidential and constitutional body. Thank you very much, my lord, for the time.
Defense counsel, you're wasting my time.
Yes, my lord.
Court register, give me a date.
My lord, I cannot hear what the prosecution counsel said.
The prosecution just closed the case.
Pardon, my lord?
The prosecution just closed his case.
Okay, my lord. Thank you, my lord. In view of this, my lord, we are urging this honorable court to give us that enable us to enter our defense. Thank you, my lord.
This matter is hereby adjourned to the 5th day of November 2025 for defense. The defendant who is on bail is to continue to enjoy the bail granted into the next adjourned date.
Thank you, my lord.
Case number FSTD and CR 39/2022 between Federal Republic of Nigeria and Garba Sarkin Fawa.
Respectfully, my lord, I am Usman Bamara. My appearance is for the complainant.
That's fine, let me have the floor.
May it please this honorable court, my lord. Eva Vice my name. Announcing my appearance for the defendant.
My lord, the matter is.
Just a minute, counsel.
Acceptable.
Yes.
My lord, the matter is selected today for continuation of hearing, and we regret to inform this honorable court that we are not ready to proceed on the ground that the witness we are supposed to bring and close our case, my lord, has been engaged of official duty outside the jurisdiction. We apologize, but yeah, we undertake in the next adjournment to produce him and close our case in the next adjournment. Thank you very much.
Is the no response from the defense counsel?
Yes, my lord. We are opposing the application made by the prosecution. Also, my lord.
Council, you are wasting my time. I'm having,
Yes, my lord, because this case has suffered series of adjournment, my lord. We are opposing the application because this case has suffered series of adjournment. At the instance of the prosecution counsel, my lord. My lord, at the last adjourned date, the prosecution counsel informed this honorable court that if he could not secure the attendance of his witness, my lord, he will foreclose his case, my lord. In view of this, my lord, we are objecting his application by asking this honorable court to order the prosecution counsel to foreclose his case to enable us to enter our defense, my lord.
My lord, I refer this honorable court to the available record before this honorable court. My lord, from the record of this honorable court, it is clearly evident that the prosecution, in the interest of justice, fair play, and equity, we have given enough leverage, my lord, to the defendant, to the defense, my lord, where we find it very difficult to arraign the defendant for over 1 year. We have adjusted this matter more than 10 times, all at the interest of the defense. My lord, I am surprised for the counsel to defendants, my lord. I expect the counsel to be ashamed, my lord, of making this submission. To be ashamed of making this submission. Somebody, my lord, who have given you for about 16 months consecutive adjournment at your instance. And today, my lord, we come and appear before this honorable court, telling this honorable court the reason why we are not ready for a circumstances beyond our control. And we undertook to do that because we always mean our words. You should have been patient in the next adjourned days. We didn't make a progress to make this type of submission. As far as I'm concerned, my lord, this I urge this honorable court to disregard the submission of the counsel to defendant, my lord. Because he who seeks equity must do equity. Thank you very much.
should it be virtual or traditional sitting?
My lord, virtual.
Virtual.
Subject to my lord convenience.
Date.
We're suggesting the same date.
My lord,
what is suggesting the same date? What does that mean? Okay, for all virtual cases, when is that? November 12th. The first one on the list, is it virtual as well? It's physical. So our next virtual date is going to be that date? Okay, thank you. In your diary, can you 12? Have we done with the cases from the question center? Because we're supposed to take cases from etc. For those that are here, they can read. This honorable court, having listened to both counsel arguments, will nonetheless adjourn the matter to a virtual sitting. This matter is hereby adjourned to the 12th day of November 2025 for virtual proceedings. The defendant is to continue to enjoy the bail grant sitting to the next adjourned date. Any case for the correctional center?
That number FS/DM/CR/53/2023 between period of Nigeria and Sabi Usman. Sabi Usman.
Respectfully, my lord, I am Usman Bamala. My humble appearance is for the complainant.
Respectfully, my lord, M.A. Madak is my name. I'm holding the brief of A.A. Musa. My humble appearance is for the defendant.
You know, the matter is selected today for defense subject matter convenience matter from our own side. We already identified that of the defendant.
The defense counsel, what are you still waiting for?
My lord, the matter is coming up for continuation of defense, my lord.
Yes.
And my lord, unfortunately, we are not able to secure the attendance of the witness we intend to adduce today. And my lord, with the testimony of defendant as DW1, my lord, I will apply to close the case for the defense. And my lord, we do not intend to address the court. Thus, we do not intend to file any written address, my lord. Thank you, my lord.
My lord, the complainant too equally waive our own right of address, my lord.
Give me a virtual date. A date. So for 12th November, all cases should be for virtual.
Convenient, my lord.
Case is called much adjourned to the 12th day of November 2025 for judgment. The defendants to continue to be remanded at the Potiskum Correctional Center to the next adjourned date.
Stop, please.
Correctional Center. Did you hear the name of the case called? Correctional Center? You are muted. Can you unmute yourself? Can you hear?
Yes, my lord. Yes,
Okay.
we hear you, my lord.
The next case is still Federal Republic of Nigeria versus Sahabi Usman.
Yes, Sahabi Usman.
Yes, where is he? Is he?
Yes, my lord. Presently.
Also,
Respectfully, my lord, I am Usman Bamala. My full appearance is for the complainant.
Respectfully, my lord. Only a mother is my name. I'm holding the group of A.A. Musa. My appearance is for the defendant.
yes.
Yes, my lord, the matter is selected today for.
You have so many devices that you need to mute some of the devices because of the echo. Yes.
My lord, the matter is selected today for commencement of hearing. And subject to my lord's convenience, the prosecution are not ready to proceed, my lord.
The prosecution.
My lord, the prosecution are not ready to proceed on the ground that the forensic analysis is not ready.
Counsel,
My
we
lord,
are
some
waiting for you.
Sorry, my lord, I took the wrong. My lord, may I be asking for 100, my lord, for the prosecution to put for us to put our house in order? We apologize, my lord, for all the inconvenience we may have caused.
My lord, we hold no objection to the application. And my lord, subject to overriding convenience of my lord, we have pending application before you.
No.
Pardon, my lord.
Go ahead.
Thank you, my lord. My lord, the application is dated my lord, the application is brought pursuant to Section 156 of the Administration of Criminal Justice Act 2015 and Section 35 and 36 of the Constitution of the Federal Republic of Nigeria, my lord.
Dated when?
It's dated the 10th day of October, my lord, 2025. My lord, there's slight typing error. Instead of October, it is written September, my lord. It's October. The 10th day of October, my lord, 2025. My lord, the application is brought pursuant to Section 156 of the Administration of Criminal Justice Act 2015 and Section 35 and 36 of the Constitution of the Federal Republic of Nigeria as amended, and my lord, under the inherent powers and jurisdiction of this honorable court.
I wonder where this noise is coming from. Is it from the correctional center?
Yes, ma'am.
Can you tell them that proceedings is going on? The noise is disrupting proceedings. You can hear noise at the background.
Thank you.
Council, are you through with your submissions?
My lord, since there's no counter file from the part of the respondent, my lord, I will humbly apply to move the application in terms of the motion papers, my lord. And equally, my lord, we heavily rely on all the deposition in the paragraphs of the affidavit. And equally, my lord, adopt the written address, my lord, attached to the application. So, my lord, finally, my lord,
bail is a discretionary power of the court, and we crave your indulgence, my lord, to exercise your discretion in favor of the defendant applicant, my lord. And my lord, we are very much aware of the fact that normally, my lord, you do not treat application bail application irrespective of the accused defendant who is standing trial for for separate charges before my lord. But then, my lord, if my lord
I
will,
do not know what you're talking about, counsel. Can you repeat what you have just said? I don't seem to understand what you're talking about.
Thank you, my lord. My lord, I said that we are very much aware that my lord do not usually treat application for bail in respect of applicant, defendant, applicant who are standing before my lord for separate.
Is counsel still online?
I just got an interruption. My lord, in respect of this applicant, my lord will consider, will notice that there are some.
I still did not get you that this court does not treat bail application.
Normally, my lord, you do not treat it as easy. Bail application, my lord, we are very much aware.
That comes before the court that has never been treated. All bail applications are treated. So you tell me that there's a bail application pending before this court that has never been brought before me, and then it's something that is just left hanging. Is that what you are telling me?
No, my lord, sorry, my lord. What I'm saying, my lord, because sorry, my lord, what I'm saying, the defendant is having two separate charges before you.
Yes.
So, and that's why I was saying, my lord, normally we are very much aware that you do not easily treat such kind of application because you are granted.
I don't work on it completely, which is wrong. You are telling me that I don't, a bail application or any application will come before me and I will just neglect it. This is what you are telling me, I'm not treating it.
No, sorry, sorry, my lord. My lord, I've withdrawn my submission, my lord. And I so much apologize, my lord. Sorry, my lord.
Putting words into your mouth. If you want to say that there are this person has two different charges before this court on different cases.
Yes, my lord.
I treat all applications. I have never not treated any application before the court. So for you to just say that I don't treat it, it's really baffling, and I don't understand it.
My lord, I have withdrawn I apologize and I have withdrawn my submission, my lord.
Because
I'm very much.
It's wrong.
I sincerely apologize, my lord. I sincerely apologize, my lord. So, my lord, we crave your indulgence, my lord, to as bail, my lord, say discretionary power of the court, and my lord, we crave your indulgence to exercise your discretion in favor of the defendant applicant, my lord. And my lord will realize that there are two female sisters, my lord, sitting in the courtroom, my lord. These
are you talking about this same case?
My lord?
Are you talking about this same case?
Yes, my lord.
You have changed or you have jumped to another case again?
No, my lord. It's a record of this application, my lord.
Okay.
Yes. A record of this application, my lord.
Yes.
So, my lord, I crave your indulgence, my lord, because my lord, the applicant. There are two sisters, my lord, sitting in the courtroom. The other one, my lord, is the one that he has a date for marriage with the dependent applicant, my lord. And the other one is
to do with Yes.
Sorry, my lord.
Counsel, I don't know where you're going. You have made your submissions in your written submission.
Yes, my lord.
The
So, my lord,
abbreviation is not making sense to me.
thank you, my lord. Much guided. My lord, this is our humble application, and we crave your indulgence to exercise your discretion in favor of the applicant. Thank you so much for your time, my lord. And I sincerely apologize for my earlier submission in trying to lay a foundation, my lord. I sincerely withdrawn it, and I sincerely apologize. Thank you so much, my lord.
Thank you, counsel. As much as I accept your apology, that you will choose your words to reflect the true positions of whatever is happening. That from what
Thank you, my lord.
your earlier submission is totally wrong. Just
Most guided, my lord. You always learn, my lord. My lord, that's one of the beauty of appearing before you, my lord. You always learn. Thank you so much for the guidance.
Yes, counsel, prosecuting counsel, go ahead.
We have not filed a counter in respect to the application filed by my learned friend. However, my lord, even we will find ourselves in a very perplexed situation with regard to the submission of my learned friend. Even though even if he apologized, my lord, it is on record, and we have to keep also a record to clear the air. My lord, I have been prosecuting before this honorable court for good consecutive 4 years, my lord. Never in my life I have ever seen an application, especially bail application, my lord, which ruling is adjourned to another date. It is treated there and then, whether it will be in favor of the prosecution or in favor of the defendant. Notwithstanding, my lord friend have withdrawn, but my lord, we find very disturbing also in our own side, my lord, for this type of submission. Counsels should be careful in their choice of words, my lord, when making their submission, especially to the jury. So I also join my learned friend, my lord, in also apologizing, and I equally advise my learned friend who is younger than me to be careful of his choice of words whenever he's making his submission. Thank you. My lord, we file no counter, and we leave it to discretionary power of the court to exercise it judicially and judiciously. Thank you very much.
This honorable court, having listened to the application and submissions of counsel, will deliver a ruling shortly.
As court please, ma'am.
As the court please.
Council, can you hear me? Can you see me?
Yes, madam.
I'm having challenges with my own device, so I had to look for another device. Correctional Center, can you hear me?
Yes.
Okay.
Yeah, my lord.
Ruling.
As proposed, my lord.
The defendant in this case is Sahabi Usman, who was arraigned before this court and pleaded not guilty to the two-count charge. His counsel today introduced the defendant's pending motion on notice, praying for an order admitting the applicant to bail, pending the final determination of the charges against him. I've looked at the motion on notice with the affidavit, 12 paragraphs affidavits. Having perused the processes, the court have formulated one issue for determination being whether the applicant in this affidavit has placed sufficient materials before this court to be entitled to the favorable exercise of this honorable court discretion to be granted bail pending this trial. When I typed in the name of this case on my laptop, an exact same name of the defendant came up, signifying that he's pending trial on a similar offense, similar narcotics, drugs, and measurements. The information which was stored in the laptop's memory. I now check the file in the system bearing the name of Federal Republic of Nigeria versus Sahabi Usman, CR 53, 2023, confirming that the defendant is indeed before this court facing similar charges and was granted bail when he was arrested on another criminal charge. What got me worried and is agitating my mind is that the defendant is before this court again with similar charges. The fact that possessing and dealing in illicit drugs has been adjudged as an organized economic crime, it seems as if the defendant is an old hand who feels that whenever he's arrested, he will be arraigned, seeks for bail, and then readily go back to the same illicit business in the hope that even if he's caught, the question of a few months incarceration and he will be released to return to the business and make good money in illicit dealing and trading in drugs. I stated so, taking account of the larger society's interest. The Supreme Court per M.T. Mohammed in the case of Doku Basari versus Federal Republic of Nigeria, 2007, 12 NWLR held that some of the required guidelines relevant to the determination of grant or refusal of bail to a defendant in matters of bail pending trial may not be admissible as evidence in the main trial, but they are certainly worthy to be taken into account in the application for bail. He also Baba Yiva State, 2001, Abacha versus State, 2002, Ekweneogo versus Federal Republic of Nigeria, 2001, Ayuba State, 1988, Yantata versus IGP, 1959, Abacha versus State, 2001, Abiola versus Federal Republic of Nigeria, 1995, etc. This honorable court, following the reasoning of the appellate court vis-a-vis the instant bail application and of the notorious fact that the court had earlier on granted the defendant bail, and while on bail, he is alleged to have committed a similar offense. And finally, taking the interest of the applicant defendant as well as the larger society's interest has a stake in every decision. The court must be alive to its environment, especially as it relates to the aspect of violence vis-a-vis the prevalence of illegal possession of narcotics in the system. The Nigerian state is undergoing serious security challenges. To a large extent, the proliferation of narcotics and psychotropic substances are among the contributory factors we as a society are facing presently, especially when we through the prison security challenges bedeviling Yobe State. There is no court of law having regard to the provisions of Section 122 of the Evidence Act 2011, by which court can take judicial notice of certain notorious facts, can shut its eyes to these incidents as it will be an act of sheer judicial expectation to pretend as if all is well in terms of internal security in the state. And I am aware of the principle that where a particular type of offense has become prevalent in an area where an application for bail is being taken, the court must also be alive to its environment without prejudging any issue or denying the accused person his undoubted fundamental right to presumption of innocence, weighing the need to exercise his discretion one way or the other. The defendant is not being judged as a commercial dealer of narcotics. The fact that after being granted bail on a similar charge, the defendant had readily gone back to the same business with similar allegations says a lot. And this is an example of incident which no court of law can afford to ignore and treat as extraneous materials which need not be reflected upon whilst considering the applicant motion and notice for bail. It is not that these incidents are to be used to deny bail to the defendant, that this court will fall short of being a court of law and justice if it pretends that all is well in the polity in terms of security of lives and properties, which in the last few years have come under relentless and mindless onslaughts, allegedly by people who mastermind the possession of illicit drugs. While the court is concerned with the presumption of innocence of the defendant, which is constitutionally granted, is protected, it must also ensure that the capacity of the state to enforce criminal legislation against an accused person is not undermined by a casual approach to grant of bail, which invariably may encourage persons standing trial to take advantage of the softness of the court to abscond. Once this happens so frequently, the capacity of the state to enforce its criminal legislations will be gravely undermined, and this itself becomes a major security issue in the polity. The court is therefore required, whilst exercising its attention closely to the materials before it. In the instant case, in the course of this ruling, I did refer to a similar charge against the defendant before this court, which is an extraneous material, but which the court must factor in or key in while exercising its judicial discretion. I agree that the issue of admitting or not admitting to the offense of charge raised may not be a ground to grant bail pending trial. It is my view that the defendant, on his part, has not provided sufficient material by which the court can come to a decision that the defendant is entitled to the exercise of the court's discretion. I've read the paragraphs of the applicant's affidavit, and it has not given this court any degree of assurance or reasonable degree of assurance that the defendant, if granted bail, will be available in his trial. And in common law jurisdictions, it is the prospect that the defendant will be available to face the trial as one of the judicial guidelines laid down by the apex court in a plethora of decisions that will determine the success or otherwise of an application as was filed by the defendant in this case. I've stated that the defendant on his part has not furnished this court with such facts or materials considering the gravity of the offense, which can give reasonable assurance that the defendant, if granted bail, will be available to stand his trial. I stated that the depositions in the affidavits in support are not, in my view, sufficient to give this court the kind of assurance it requires that if his discretion is exercised in favor of the defendant, he'll be able to stand trial. Let me again state that I'm not in doubt that the offense alleged in the charge is a bailable offense, notwithstanding the seriousness of the offense and the severity of the punishment prescribed by law, and a refusal of bail does not remove the constitutional presumption of innocence in favor of a defendant. When all these issues are taken together, I'm constrained and found it rather difficult to exercise my judicial discretion in favor of granting bail to the applicant defendant, considering the analysis done in the body of the ruling. Consequently, the application for bail filed and argued on behalf of the defendant applicant is hereby refused for the reasons I've given in this ruling. Also, I've taken cognizance of the submissions of the defense counsel, which is really, like I said, is really troubling. Because I stated earlier, I was alarmed by the submissions of counsel, which is baffling, and I appreciate the correction made by the Leonard Prosecuting Counsel, who had appeared, as he has stated several times, countless of times over the years, And all counsel will bear witness that I never leave any pending application pending. I'm repeating it, I never leave any pending application pending or hanging. So I presumed that the defense counsel meant to say that most applications whereby defendants are having two different charges before this court, I hardly grant bail. Usually I grant bail in all manner of cases. But if a defendant is granted bail and he has gone back to commit allegedly the same offense within a very short period, in less than a year, then it's alarming. And when you look at this, I don't look at a case just from the prosecution side or based strictly on the defense side. I look at it whole. So when you look at such things, there are so many things to ponder. So like I stated, the application is refused. If it, go the next case.
Act number FLC/DM/CR/4/2023 between the Federal Republic of Nigeria and Garba Alhaji Hassan.
Garba Al-Hassan Jandari. Yes, my lord.
Oh, this Sally name called?
Yeah, at the correction center, my lord, and speaker.
Garba Alhaji Hassan.
Yes,
Alhaji Hassan. Alhaji Al-Hassan. Garba Alhaji Al-Hassan.
Yes, Garba Alhaji Hassan.
Representation, please.
Respectfully, my lord, I am Usman Bamada. My humble appearance is for the complainant.
Respectfully, my lord, M.A. Madak is my name. I'm holding the brief of Umar Hassan. My humble appearance is for the defendant, my lord. Yes, my lord, the matter is coming up for continuation of defense. And unfortunately, my lord, we are unable to secure the attendance of witness we intend to adduce today. And my lord, in view of that,
Your submissions again, counsel.
my lord, the matter is coming up for continuation of defense, my lord.
Yes.
And unfortunately, we are unable to secure the attendance of the witness we intend to adduce today. So, my lord, in view of that, with the testimony of the defendant as PW1, we humbly apply to close our case for the defense, my lord. And we do not intend to file any written address before the court, my lord. Thank you so much.
Yes, my lord, we also waive our own right of address, my lord. Thank you very much.
Give me a date.
12th November.
November. It's ready by then. This matter is hereby adjourned to the 12th day of November 2025. The defendant is for judgment. The defendant is to be remanded at the Potitum Correctional Center. Proceedings by virtual mode.
Thank you, my lord.
Yeah.
My lord, I was not able to get the date for the
12th November.
Daga zuwa ranar 3 ga watan 11 ranar ne za a gabatar da hukunci.
Sorry, my lord.
Charge number FS DM/27/2025 between Kira from Nigeria and Kachella Asami.
Yes, my lord. Yes, my lord. That is all, my lord, for the correctional, my lord.
Okay, for the correctional center, the cases for correctional. Okay. Okay, for correctional center, thank you so much for joining.
Thank you, my lord.
Thank you,
Very much.
Mr. Salisu as well. Okay.
Thank you very much, my lord.
Okay. Can you just show the defender so that they can see this? Okay. This device is not. No, I have no choice. We have to continue like that. Okay. Representation.
Respectfully, my lord, I am Usman Bamada, my humble appearance is for the complainant.
May it please my lord. My name is I.M. Halle. My lord, my appearance is for the defendant.
Yes, my lord, the matter is fixed for commencement of hearing.
Yes.
The complainant, my lord, regret to inform this honorable court that we are not ready to make a progress in this matter on the ground that the forensic analysis is not ready for us to make a progress with this matter. So, my lord, in these circumstances, may we be asking for a date which hopefully we will open and even close our case on that very day.
My lord, we are not objecting to the application made by the prosecution, as this is the first adjournment, my lord, and today is the date for the
Counsel, I can't hear you. Your audio is not so loud. I can.
My lord, I'm not objecting the application just made by the prosecution, as today is the first day for commencement of the hearing, so we are not objecting to it, my lord.
Date. This matter, is it virtual or traditional?
My lord, traditional.
Yes.
Traditional.
Yes, my lord.
Okay, give us a date.
Not 5th November.
How many cases do we have on the 6th?
On 6th? On 6th, we don't have cases. It's only on 5th we have 5 cases.
No, I have 6 here.
We have 5 here. 5th November.
Do you have Adamu Dodo there?
No, there's no other model.
Yeah.
I think it's 4.
It's 4 when?
4. Adamu Dodo is 4.
12?
Yes, Adamu Dodo.
Just give me a minute, let me confirm. Check the file. What? The Adamu Dodo, is he not on bail?
He's on there.
So why virtual? Was that the, let me have the file, let me confirm from the file. Because I don't have it on the 12th, I have it on the 5th. Quickly, Mr. Mustafa, just the last page. Let me have it. The last page. Okay. I have 5th November.
Okay.
Oh, that's what I have on my proceedings.
Okay.
And I have it written in my diary as well.
Okay, good.
But unless if council applied for a virtual proceeding, let me still have that page. Because the defenders, they are to enter their defense. There's nothing about virtual, so it should be 6, not 12. And all the other cases for 5th, can you confirm? Are they all for hearing? Can you confirm for me?
One is for opening of defense, number 2, continuation of defense, number 3 is continuation of definite hearing, number 5 is continuation of hearing. Then the other one is for commencement of hearing.
This matter is hereby adjourned to the 6th day of November 2025. The defendant who is on bail is to continue to enjoy the bail granted him till the next day.
As the court pleases. My Lord, we are very much grateful. And my Lord, with your kind permission, I would like my Lord to say 1 or 2 things regarding the just submission made by our learned colleague, my Lord. And my Lord, I would like to use this opportunity, my Lord, on behalf of the said Madaki, my Lord, to use the word sorry and the apology, my Lord, he has tendered. Even though, my Lord, you have accepted the said apology he has made before you. And honestly speaking, my Lord, the way and manners he used in addressing you or in moving the motion is quite unacceptable to anybody, my Lord. So on his behalf, my Lord, and the entire councils appear before you today, we, my Lord, use the words, my Lord, sorry on that behalf, my Lord. So we are very much sorry, my Lord. And I promise, my Lord, that personally I will meet him and talk to him regarding what he has just said in his submission, my Lord. So, my Lord, once again, we are very much sorry for the submission just made by him, my Lord. So we are sorry, my Lord. We are sorry. And we can bear you witness, my Lord, all applications, whether they are meritorious or frivolous, be filed before you, my Lord. You do entertain them with utmost pity, my Lord. So we have never seen an application or situation whereby an application is said to have been filed before you and the said application has not been treated, my Lord. That one, anyone who said that one, my Lord, honestly, he's unfair to you and he's unfair to himself. So we can bear you witness, my Lord. We as private lawyers, my Lord, we always do inform our colleagues that if they want a speedy trial or speedy application to be entertained, my Lord, that if this your court, my Lord, have a jurisdiction to entertain the said application, that they should come over to you. Most of your application, my Lord, they are being treated with a speedy trial, my Lord. We can bear you witness to that one. And my Lord, if I were him, after moving the application, I would just allow the court to rule on it. That is all, my Lord. But bringing the issue in order maybe to convince the court is the main issue that resulted to this incident, my Lord, or maybe to his frivolous submission. So, my Lord, we are very much sorry. We are very much sorry, my Lord. Thank you very much.
Thank you so much, Council. Really appreciate. And I think even for Council, it's what I'll say, maybe poverty of words.
Yes.
What he intended to say didn't come out the way he wanted.
Yes.
Maybe he's anxious. He wanted his client to be free. So whatever it takes to say, but the way he said it was not right or was not, yes, it wasn't correct. So it's
Yes.
a mistake that he made, but I still believe that his intentions were not malafide. So the way he went about it definitely is wrong, and I'm happy that council have come out in defense of what he has done, which is not right, because even expert motions, 5 o'clock, I do sit on such. I don't allow any application to lapse. So I think in his own way, he's worried for his main concern is his client, but the way he couched his
submission,
his wordings was wrong. He didn't appreciate what he said. He didn't, because the meaning of what he said is truly not good. Because not that if it's the truth, it's okay, but this is not the truth of the matter. So I think maybe he realized that actually what he has said is not wrong, because like you, or both counsel that have come to the defense of the court have stated that I don't leave any pending lingering application, no matter. Like the prosecuting counsel have stated, whether for or against, no matter what, no matter how late, I try to see that that application is determined. Applications are brought any time of the day, even after closing hours, like I said, at 5 o'clock, sometimes on Friday. So it's okay. No, like I said, it's not malafide, I believe. So from my own side, it's still the same thing. But I thank counsel for your concern in trying to rectify the situation. Thank you so much.
You're welcome. Thank you very much.
Okay. Can we go on to the next case? Oh, that is it for the day?
Yes.
Okay, I will appreciate counsel as well as the staff of court. Today's proceedings have not been so smooth. It has been stressful on my own part because I've been changing devices to enable me work. And I know from the side of counsel as well. But my grounds with counsel is sometimes you don't pay attention. I have to keep prompting you. It's just like the court. In court, we don't, it's always seamless. But when it comes to virtual proceedings, counsel forget that they are in court. You find counsel just discussing amongst themselves or that is what it causes a bit of some noises, etc. But we are still learning. It's a new initiative and we are learning, and I thank Council as well as the staff of the Federal High Court as well as the staff of the Correctional Center. Okay, thank you, Council. Appreciate your assistance. Thank you.
Thank you very much.
Okay. You can check your device. Thank you so much.